promise 3 often overlooked documents, and these are important. So let's just go through them one by one, because a lot of people don't think about these, probably because they don't know all the details and why they're so important. So that's what we want you to learn today, is about these documents and why they may be important for you to have as part of your legacy plan. Let's first talk about the medical power of attorney.
The medical power of attorney, this is a document that will be used while you're alive. In fact, when you pass away, it's no longer valid. But the medical power of attorney will give somebody whom you trust medical decision-making ability. So you become incapacitated, you can no longer make medical decisions on your own behalf. This individual can step in and make decisions based on the directives that you put into, in most cases, a live-in will, or sometimes the medical power of attorney as well will spell out what this person can or cannot do. But it's ultimately imperative to make sure that somebody you trust, who is as knowledgeable as they can be about the medical decisions that they can or cannot make, has that power, and then that way you're not as dependent upon the hospital or the doctors to make those types of decisions for you.
The next one is a financial power of attorney.
Very similar to the medical power of attorney, except for the financial documents. So an individual or individuals who can make financial decisions for you. Do you need to take distributions to continue to pay the taxes for the property, the insurance, keep the lifestyle going, or are there other decisions, financial decisions that need to be made? This would be encapsulated within that financial power of attorney. And oftentimes the direct abilities that this individual that you're granting these powers, those abilities will be highlighted in that document as well.
And that's while you're living, correct? That one?
That also is while you're living, and it becomes invalid once you do pass away.
And the third document we have is a revocable trust. How's that a little bit different than what you outlined on the board?
The revocable trust is exactly what the name describes. You can change it, you can revoke it, you can get rid of it, you can amend the details within that trust. Once you pass, it becomes permanent. So once you pass away, nobody can change it, and then the directions that you put in that trust should be played out through the trustee that you designate in the trust. So within the trust, you're going to designate this is an individual or individuals that you trust to be the trustee to execute the orders that you have within that trust.
And one thing to talk about maybe with the trust, to think about anyways, is it can be important for blended families, or maybe if you're on a second marriage as well.
The blended family situation is more prevalent than what it ever has been before. Recently, I was meeting with a married couple. They've been together for about 7 years, but they both have kids outside of that particular marriage. And they said to me, both, and they were in agreement, let's call them again, John and Sue. John said, I want to make sure that Sue is taken care of if I pass away, but also once Sue passes away, this I want to go to my kids. Sue said the same thing. Sue said if she passes away, she wants John to be taken care of, but then she wants her assets to go to her kids. Again, that doesn't happen by accident. You need to take specific steps to make sure that does happen. And this blended family situation is more prevalent than it ever has been before. And if you're in a blended family situation, you want to make sure that you're both in agreement to as much as you can be, because not always do you agree.
What? No, that never happens in my marriage.
Never happens. But the legal documents that you put together do need to be coherent, and they need to represent what each one of you are feeling. So those conversations aren't necessarily fun. But I can tell you, working through it now, prior to something taking place, is a way better experience than you passing away and then having the kids fight for it or have to deal with all of the mess that you leave by not putting the plan together.
Yes, and working through it now when you're not under duress of someone's health failing or duress of, all the other things that could be happening, working through it and with a neutral party too, either your attorney and or your retirement planner who can kind of look at it through a lens that maybe can help you make some decisions.
Yeah, or even divorce. We're talking about death, but what if you get divorced? The gray divorce is a real thing. There's a lot more baby boomers getting divorced than ever have been before. While things are still good and cohesive, if you can put these things into place for those what ifs, pass away, divorce, whatever that is, the outcome will be more desirable than if you do not.